The judge in the Wade Wilson murder trial reasoned that given anything less than the unaliving penalty to Wade Wilson, a tattoo-loving 30-year-old who, in 2019, unalived two women in the space of a few hours, would have been an affront to justice itself. Can not sentencing someone to death really be unjustifiable, as Judge Nick Thompson claimed, at least when keeping the person locked up forever is available as an alternative punishment? This is the very argument that Wilson's lawyers used to try to persuade the judge to reject the jury's recommendation of the unaliving penalty for Wilson in favour of a sentence of life imprisonment without parole. They clearly got nowhere with that argument, however.
I remind the court that the jury's recommendation was 9-3 for one victim and 10-2 for the other. Under their previous statute, that would have required this court sentence my client to life.
With his many face tattoos, Wilson instantly became something of a TikTok trend when, in June 2024, he stood trial for MURDE you-know-what. While he argued, as part of his defence, that his crimes came from his lifelong impulsiveness, which is out of his control, the jury deemed that he had, in fact, acted with premeditation. Added to this is, as you're about to learn, the fact that when he unalived Christine Melton, 35, and Diane Ruiz, 43, Wilson was lucky to even be out on the streets.
Case, the totality of the circumstances indicates the defendant, with premeditation, beat and strangled Christine Melton in her home before stealing her vehicle and driving to meet his girlfriend, Melissa Montanez. After Montanez refused to get into the car with him, the defendant battered her in broad daylight. The defendant told law enforcement, when Ms. Montanez managed to flee from the defendant, he fled the scene and drove back to Cape Coral, where he decided that he would murder another person. He saw Diane Ruiz walking to work and pulled over, pretending to ask for directions. She got into the car to provide directions, but the defendant strangled her when she tried to exit. He then drove to an empty lot, strangling her into unconsciousness at least one additional time on the way there. When she tried to flee from the car, he drove over her at least one time, inflicting mortal injuries to her spine, ribs, and neck. The evidence showed that both murders were heinous, atrocious, and cruel, and that the second murder was cold, calculated, and premeditated. The defendant inflicted serious physical and emotional pain to the victims. Moreover, the defendant committed the murders while on probation for prior felony convictions, and he committed two first-degree murders contemporaneously with each other and with grand theft of motor vehicle, battery, and burglary of a dwelling.
That's how he thanks the parole board for letting him out of prison. In weighing the mitigating factors to Wilson's case against the aggravating factors, the judge concluded that there wasn't any meaningful or credible mitigation for Wilson's crimes. Rather, there was an overwhelming degree of aggravation.
The totality of the mitigating circumstances indicates that the defendant suffers from drug use from a young age, along with undiagnosed and untreated mental health issues of some kind. He felt abandoned by his biological parents, but had a devoted adoptive family who raised him in a supportive and loving environment. Defendant did not resist law enforcement when arrested and confessed fully to both murders.
On the point of Wilson's confession of his crimes, I can only think that the reason why he had to stand trial is that he no less pleaded not guilty to murder. When you plead guilty, no trial is needed and no trial takes place. Anyway, let's get back to the judge.
The court has further considered giving great weight to the advisory verdict of the jury, who recommended that the death penalty be imposed by a vote of 9-3 on count 1 for the murder of Christine Melton and a vote of 10-2 on count 4 for the murder of Diane Ruiz. The court carefully considered the nature and quality of each aggravator and mitigator. Having reviewed all of the aggravating factors proven beyond a reasonable doubt and all of the mitigating circumstances reasonably established by the evidence, the court finds that the aggravating factors greatly outweigh mitigating circumstances. Given the facts of the case, nothing in defendant's background or mental state would suggest that a death sentence is inappropriate. This court's review of other reported capital cases has led the court to conclude that the death penalty is not disproportionate in this case. Under the totality of the circumstances and evidence, the court finds no basis to override the jury's verdict.
As you just heard, the judge essentially says that the death penalty is a proportionate penalty for Wilson's crimes. In American law, the death penalty is never mandatory, but we've just heard that its imposition in Wilson's case is consistent with case law. Previous cases where the state of Florida, because that's where the trial took place, has imposed the death penalty. So given that, it would be unfair not to impose the death penalty in Wilson's case. No judge wants to trigger a flurry of appeals against the death penalty from people currently on death row. That's an important consideration, I'd say. And to give a comparable situation from the UK, I'm under the impression that in 2010, Roy Whiting, who in 2000 unalived 8-year-old Sarah Payne, got his initial 50-year minimum prison term reduced to 40 years because in 2003, for unaliving not one but two 10-year-old girls, Ian Huntley got a 40-year minimum term. Anyway, let's let the judge round off.
The totality of the circumstances warrants that the defendant, Wade Stephen Wilson, be sentenced to death for each count of first-degree murder.
Honestly, chin raised, leaning back on his chair, legs open, comfortable, confident, casual, this unaliver has no shame and no remorse. He's enjoying having his evil crimes replayed to an audience, which includes him himself, and I can prove it.
He decided that he would murder another person. He saw Diane Ruiz walking to work and pulled over, pretending to ask for directions. She got into the car to provide directions, but the defendant strangled her when she tried to exit. He then drove to an empty lot, strangling her into unconsciousness at least one additional time on the way there.
There you see, licking his lips and chewing with his mouth closed. Hearing someone read out the way that he unalived Mrs. Ruiz is tasty to him, mouth-watering. He can't get enough. He feels like he's doing it all over again and wishes that he actually was doing it all over again. Well, that's how it looks to me anyway. His markedly sadistic nature was already proven in any event by what we learned of how he carried out the first of his two MURDE weeks before Judge Nick Thompson imposed the death penalty on him, which he did on the 27th of August 2024.
But I think it's important to start at the beginning of this case, where it all happened, off McGregor Boulevard, near College Parkway, at the Buddha Lounge. Music was playing, people were socializing. The defendant went there to have a good time, and he discarded the woman he came with, and he chose one that caught his eye, Christine Melton. And as he told detectives, this is what I do with women, you know. I use my charm, I use my good looks. That's what I did with the first girl, and that's how I got in her head. And look what happened to her. When the defendant first approaches Christine, he's not threatening. He's smooth, he's charming. He's nice to her and her friend Stephanie. They party together. No red flags, no sign of aggression. He's a fun guy, but he waits. He waits until he's back at her house, in her bed, and Stephanie has gone home. He waits until he is alone with her, until there are no other witnesses. He waits until she is asleep, defenseless. The defendant says she can't get away from him, even if she wanted to, because he's too strong. And when she can't get away is when he kills her, when he strangles her, because he was the lion and she was the prey.
Wilson himself conveys his total remorselessness in a jailhouse call to an ex-girlfriend of his. And before you ask, I don't know whether she was the one that he beat up directly before going on to unalive Diane Ruiz.
Well, then tell me what happened then. I deserved it.
Killed.
Why, Wade? Why?
Because we went to this dude's house, Mila, and remember when he kept showing us the pictures? Oh, I got this, to get this, or whatever?
Yes.
So I went to his house, and I did a lot of it. Like, he was giving me a lot. And I was doing a lot of...
Why did you kill the girl?
Huh?
Why did you kill that girl?
I shouldn't have. I'm wrong.
Tell me what happened. Did you have sex with her? You went and killed her? What?
No, I didn't have sex with her. I killed her, though.
Yes, I know he says that he shouldn't have unalived Christine Melton, but there was still no sorrow or remorse whatsoever in his voice, in his tone. He may as well have been conversing with his interlocutor about the weather or about the outcome of a football match. I'll come on to what the law says about committing a crime due to intoxication presently, drug use being, as you've just heard, Wilson's explanation for unaliving Miss Melton. First though, let's listen to Wilson's personal account of how he unalived Diane Ruiz.
Yeah, but did you kill the second girl at that point?
No, I think I killed her later.
You think?
Yeah, I'm pretty sure I did. I killed her after I saw you.
Remember this stuff. These
What,
are
babe?
like usually things that people remember when they kill somebody.
I killed her after I saw you.
Why? Why couldn't you just rob her? Why did you have to kill her?
I'm sorry. I don't know.
Why? I kind of want to know why. What was going through your head when you're killing her? So I heard that you choked her out. She didn't die. She got up and ran. You ran her over with the car. Is that how it went?
That is, yeah, it is. She didn't get up and run. She didn't get up and run. That's not true. I choked her out, pushed her out of the car, and then I ran her over with the car.
How did you get her in the car?
She got in by herself.
So she got in the car by herself,
Yeah.
and you took her out in the car,
Yeah.
pushed her out of the car, and
Uh-huh.
then you
Ran her over. Yeah, like 10
Do you
times.
not hear yourself?
Yes, Mila. I do. I hear
Does
myself.
this sound like something that you want to be saying out loud? Can you believe that you've done this?
No, I can't. I really can't. I was on drugs, dude. I really can't believe it.
Asking for directions, demonstrating neediness, winning Mrs. Ruiz's trust. Funnily enough, presenting with vulnerability towards his victims, all women and girls, was precisely how serial killer Ted Bundy ensnared most of his victims. As to the matter of committing a crime due to being drunk, in UK law, for the most part, drunken intent is still intent. A person's drunken state can come from any dangerous drug, and in the law of England and Wales, alcohol is deemed a dangerous drug. For the most part again, if you commit a crime when you are voluntarily intoxicated, you are fully criminally liable. You are the one who voluntarily put yourself in the position of not being able to control your behaviour. If, however, you want to convince the jury in your murder trial that your voluntary intoxication came, in fact, from a recognised medical condition, meaning that your intoxication was not actually voluntary at all, then yes, the burden of proof in that scenario is very much on you. Expect the prosecution to rip your argument of diminished responsibility, loss of control to be exact, to shreds, or to at least try to. Diminished responsibility is a mitigation that only applies to cases of murder. I don't know what the laws of Florida say about crimes coming from voluntary intoxication. Wilson has been sentenced to death though, so his drug addiction clearly didn't serve him in any way as a defence, and we already heard the judge say that Wilson essentially has no defence. The reason that a person with a death sentence can sit on death row for years and years is, apparently, to allow time for any appeals from the person against either the sentence or the conviction itself. US law endeavours, you see, to avoid mistakes where the death penalty is concerned, executing an innocent person or executing someone who is guilty, but who comes with adequate mitigating factors for a punishment other than death. It's all to do with the legal principle of habeas corpus. Wilson seems to think that he's in with a chance of getting out of his death sentence.
You would have that opportunity if you wish. No one can prevent you from addressing the court if you wish to, and no one can make you address the court if you don't want to. So it is a decision that's solely left up to you if you want to address the court or not.
Not today. Later, when I come back, I will. Today,
Okay.
no, I won't.
Okay.
If you've enjoyed this video, I recommend you to watch this one next. I'll meet you there.